Hello, everyone. Welcome to our webinar, Animal Law and Environmental Law, Parallels and Synergies. Thank you so much for joining us today. I'm Lu Shigai, the Managing Director of the Institute of Animal Law of Asia, and I'll be moderating today's webinar. Institute of Animal Law of Asia, or ILA, is the educational research center that focuses on animal law issues in Asia and the world. At the ILA, we provide research projects which include animal law in Asian countries, on topic, on category, and on species animal law articles. Last year, we have launched a few external projects under the Global Ambassador Program. These are enhancing legal regulations for aquatic animals in Kazakhstan, farmed animal welfare in mainland China, and amplifying the interests of animals in Kazakhstan. All of this are sponsored and supported by the Center for Animal Law Studies, Lewis and Clark Law School. We also have our news source, Asia Animal Law Bulletin, which provides the latest updates on animals in Asian countries and regions, as well as our recent initiative, the Alliance for Animal Law of Asia, which is the international networking campaign that aims to cooperate with national, regional, and global animal organizations through legal education, collaboration, online events and webinars, and inviting experts to share their experience with our audience. Our members are spread across the globe, from Asian organizations in China, India, Indonesia, Japan, and Vietnam, to the organizations on other continents, including North America, South America, Europe, and Africa. Oh, I'm sorry. In case if you missed some of our past webinars, you can find the recordings on our YouTube channel. It's Institute of Animal Law of Asia, or go to our website. It's ilasia.org/events. Usually we provide the recordings of all our webinars. So if you're interested, you may find them up there. Please don't forget to check out our website. It's ilasia.org, and follow us on social media. It's Animal Law Asia on Facebook, Instagram, Twitter, YouTube, and LinkedIn. Our guest today is Randall Abate, a professor in the Department of Political Science and Sociology and the director of the Institute for Global Understanding at Monmouth University, who has delivered numerous lectures and taught international and comparative law courses on environmental law and animal law in more than 20 countries. He is the author of the book, Climate Change and the Voiceless, Protecting Future Generations, Wildlife and Natural Resources, the editor of What Can Animal Law Learn from Environmental Law, Climate Justice, Case Studies in Global and Regional Governance Challenges, and Climate Change Impacts on Ocean and Coastal Law, US and International Perspectives. He is also the co-editor of Climate Change and Indigenous Peoples, The Search for Legal Remedies. We'll be answering questions after the presentation, so please drop your questions in the Q&A box. Thank you so much for being with us today, Randall, and for giving this talk. We're all looking forward to learning from you.
Thank you so much for that kind introduction, Lou. It's an honor to be here. I'm just very impressed with what the Institute of Animal Law of Asia has done in a short period of time, and it's really an honor and a privilege to be part of this distinguished webinar series. I noticed so many of my colleagues around the world who have already been invited, and highly recommend to the attendees to check out the website and the previous sessions. I'm going to share my screen. Great. Okay, so I want to give you a brief overview of what I'd like to cover in this presentation. I'm planning to speak for about 40 minutes and eagerly anticipate your questions and comments. I want to give you a sense of the evolution of the book project that I'll be drawing case studies from today. And I do that because my starting point in this presentation is that I'm not your typical animal law professor, and I'll explain what I mean by that. And then I want to go into history, politics, and law as foundations for what I want to address in considering the different trajectories of environmental law and animal law. And this is certainly with a US lens. That's the foundation of my experience, but it tends to be comparable in countries throughout the world when looking at environmental law and animal law, some of the comments that I'll be making in comparing the two movements. And then I want to give you a select lessons from environmental law that can aid animal law in advancing more effectively. So if we think of environmental law as the big brother or big sister movement that has blazed a trail very effectively in many ways, and how animal law can piggyback, pardon the animal pun, on some of those successes that environmental law has achieved, that's certainly one focus for my remarks today. And then the second piece, equally important, is the idea how these two movements need to work together more effectively than they currently do. And so I'll give you two contexts for that discussion as well. And I'll conclude with two case studies from the second edition of the book that are very cutting edge and highly relevant topics for thinking about how animal law can learn from environmental law and how these two movements can work together more effectively. So this is the cover of the second edition, and it's not your typical second edition, just like I'm not your typical animal law professor. So the first edition of this book came out in 2015, and it was 17 chapters. 5 years later, the second edition came out, and in addition to updating those initial 17 chapters, 12 new chapters were added in the second edition. So the coverage is significantly broader and very current. It was published in July of 2020. And I want to give you a sense on this slide how I came to teaching and writing about animal law, this non-traditional path. So the first comment I want to make is that I was an environmental law professor for what was at that point the vast majority of my career. I was in practice as an environmental lawyer for 4 years, and my career was devoted to teaching and writing about environmental law. And animal law really wasn't on my radar screen. And then I was approached by students at the law school I taught at the time, Florida A&M Law School, to teach an animal law course for the first time at that school in 2014. And I was very eager to take that on at the time because I was becoming more aware of animal law at that time. I had coached some animal law moot court teams. That was really kind of my first formal introduction into animal law and really enjoyed it. I saw at that time, as I was preparing to teach the course and teaching it for the first time, I started to see a lot of similarities between what I had learned and knew about environmental law's history and track record of success and challenges. And I saw that reflected in animal law, just perhaps 2 or 3 decades later than environmental law had confronted those issues. And so I became very interested in the relationship between these two fields, and my background in environmental law certainly informed my approach to animal law. And I started by saying I'm not your typical animal law professor, in that I'm probably the only animal law professor in the world who does not have a companion animal. That's probably the most important thing to know about how I'm different. Many, if not all, animal law professors really came to the field through that sense of moral stewardship and compassion for animals. And I always had that, but it wasn't driving my interest in animal law. I came to animal law through environmental law, so I have a very different lens on animal law as a field. Very much a supporter of all of the reasons most animal law professors come to animal law, but it's not how I got here. And so I think that's been something that has directed me in how I think about these two fields and how I approach animal law. So the book has those two goals, really, about how the environmental law experience can inform, and also how inform future directions for animal law, and how these two fields can work together. So I really want to address both of those themes as we go through the presentation. But one thing I do want to note, and this is something that, as much as I want to inform animal lawyers and animal law professors with these messages, as an environmental lawyer and environmental law professor, I feel like I've become a better environmental lawyer and environmental law professor because of my foray into animal law. It's certainly given me a broader, more interdisciplinary perspective on environmental issues, and it's re-energized me in many ways. I've really, in many ways, I've really felt a renewed passion for many of the issues that I take on, and that's true for both fields. But environmental law had that passion back in the 70s and perhaps into the 80s, and then the field really became institutionalized in a way that animal law has not. Animal law still has that passion that environmental law had and perhaps lost. It's only of late that I feel that environmental law has regained some passion on its own with the climate justice movement, which is another area that I spend a lot of time on. But I think it's really empowering for environmental lawyers and environmental law professors to be able to immerse in animal law and see the opportunities to advance environmental law. So it's very much a two-way street. So this slide I like to share because the history of how environmental law succeeded is very instructive in thinking about how animal law has failed to succeed in many of the ways that environmental law has. So if we look at history of the environmental movement and how it really became institutionalized in a good way, how in the 1970s the environmental regulatory framework in the US just exploded with major environmental statutes at the federal level, and really had fueled this environmental awareness revolution. When you think about why that happened, it wasn't because we all of a sudden developed an appreciation of the intrinsic value of nature. It was very much driven by connecting the pollution we were causing to the environment to our health and safety as humans. And if you think about those laws that were enacted at that time, the Clean Water Act, the Clean Air Act, the hazardous waste laws, all of those laws ended up achieving the consensus they needed to be passed because they were such palpable public health and safety crises that those threats from pollution were causing to humans. And of course, when you think about animal law, that is just not the story of the movement at all. Animal law really started and still has that foundation of moral responsibility to protect non-humans because we ought to, because it's the right thing to do, not because we have to, not because there's some threat to our health and safety if we don't protect animals. That's starting to change though, and that's good news for animal law, and I'll get to that in a moment. The other issue is the politics of it all. So when you think about what is more likely going to be embraced by any federal legislature, whether it's the US Congress or otherwise, it's going to be issues that are perceived as imminent challenges for humans, not non-humans. And it's going to be issues that have economic significance for humans. So those two realities are very much stacking the deck against animals being protected through federal efforts, because what's in it for humans, what's the economic imperative in protecting animals? And so that narrative has improved now compared to where we were maybe 10, 20 years ago with animal law. There are much more compelling arguments that it is very much in human interest to protect animals, and it does have significant economic consequences. But that has been much more of a challenge than it was for environmental law because of that much more apparent connection between environmental pollution and humans. And finally, when we look at the legal framework in these two movements, that federal legislative framework that environmental law enjoys is very difficult for animal law to achieve because of the nature of environmental problems. Environmental problems are inherently transboundary, and that requires this coordinated federal response to many of these challenges. That's not what we see with animal law. It's very difficult to get effective federal responses to animal law. This is largely a state law field. And that's starting to change slowly, but again, that's one of the fundamental differences between these two fields. And then the other piece is how environmental law, that revolution in the 1970s in the US, was very much driven by good science. It was the science that was telling us how much in danger human health and welfare was from these forms of pollution. And that's only starting to take hold with animal protection. So we're getting very important developments in animal sentience science, and that's really helping animal law achieve its objectives. But that's very, very recent and still very much a work in progress. And I'm going to share some links with you at the end of the talk that will illustrate some of these points. The UK, for instance, recently recognized sentience of octopuses and crabs and lobsters, which is a huge development. I mean, this would have been unfathomable even 5 years ago. And so to the extent that those kinds of efforts are happening, and they're happening because of these developments in animal sentience science, you can see that animal law is catching up to environmental law, but its challenge is much greater than what environmental law faced in terms of federal governance and science-driven initiatives. So this slide is about where environmental law has been and where it is now. So environmental law, very early on, really before it was a field in the US, it was initially at the turn of the late 1800s, early 1900s, there was a movement about protecting the wilderness for its own sake, leaving nature alone, and the national park movement, and the appreciation of aesthetic values in nature. So we have some federal laws that do protect those interests, but then there was a big gap between that era and the pollution control era of the 1970s. And that's where the focus of environmental law really shifted to this public health and welfare focus, rather than the intrinsic values of nature needing to be protected. And then most recently, we are in a rights-based era. And this is initially started with the environmental justice movement in the late 80s, and that has transformed into the climate justice movement. We still have environmental justice as its own subtopic in environmental law, but climate justice has really taken center stage with the environmental rights approach to issues. So it's kind of this merger of environmental law and human rights into one inquiry that has really taken hold of late in environmental law. Animal law has a very different trajectory. And here we see that that first stage in the US was exclusively state law based. It was a big victory that finally all 50 states do have some form of anti-cruelty protections, misdemeanor and felony protections against anti-cruelty or against cruelty to animals. And then at the federal and international levels, this is the biggest dichotomy. Environmental law, just a burgeoning number of initiatives, federal and international. Again, because of the inherently transboundary nature of environmental problems. And when you compare that to animal law, there's virtually nothing. The US has 3 federal animal laws, and they are very, very limited in their effectiveness. But what we've seen is that that third stage of animal law is very much like the third stage of environmental law. It's the rights-based approach that's really taking hold. now with the animal law movement. And I'm going to be discussing some of those efforts, and they've been very promising in the US and perhaps more so outside the US. Not for a lack of effort in the US, it's just we have some legal obstacles in the US that other countries don't face. And the animal advocates in the US, one of whom you've heard from in this webinar series, Kevin Schneider and the Non-Human Rights Project, they've done fantastic work in advancing the animal rights agenda through their litigation and legislative efforts. So I want to give you two select lessons here for animal law that come from environmental law, part of what has been successful in environmental law and how that can be transported to be of value for animal law as well. So the first issue is this idea of information. Environmental law in the US is premised on this notion of information being ultimately valuable. And the information has two components. One piece is the idea of being able to access information. And the other piece is the dissemination of relevant information to the community. Both of these aspects of how information works for environmental law have been enormously successful in the US. So this idea of transparency. So our Clean Water Act, CWA, has a framework where regulated entities have to provide what are called discharge monitoring reports, DMRs. And this is the ultimate in transparency. They are not merely providing this data to the government that regulates them, but this information is accessible to the entire public. And that's been incredibly effective for citizen enforcement of those laws, because this is not something that's behind closed doors. It's publicly accessible information that environmental groups can then access and use as the basis for a lawsuit against those entities that are out of compliance with their permits. And a similar concept is the community right to know law at the federal level, called EPCRA, a long acronym, for the Emergency Planning and Community Right to Know Act. And this has a similar foundation of information access, that there is a right to know about what companies are producing of a nature of hazardous chemicals that could be a threat to your health and welfare in your community. You have that right to know and access what is happening to protect yourself more effectively. And then the dissemination piece has really been a hallmark of environmental law in the US. This is our National Environmental Policy Act, NEPA. It's based exclusively on information dissemination. So this idea of requiring federal agencies to prepare an environmental impact statement before they proceed with a major project, it doesn't sound like much, but it's been enormously successful in delaying, if not halting altogether, projects that would have been very destructive to the environment. This process allows for publicity about the negative impacts, and it causes delay sometimes to a degree that there will be a change in administration, so that if a Republican administration was trying to pass a particular initiative and the delay causes a transition in power to a Democratic administration, that potentially harmful project will be defunded and it won't proceed. And that's incredibly powerful. And I say all of that because when we think about animal law, there is nothing of the sort going on in the animal law field. It's the complete opposite of what I've just described. Much of what harms animals goes on behind closed doors. When we think of perhaps the two most harmful sources of animal injuries and death, factory farms and medical research facilities do not operate under these premises at all. It's virtually impossible to penetrate these fortresses. Animal rights activists have to work extra hard to gain any kind of insights about what's happening there. And so they resort to efforts of undercover investigations to learn about what's happening. And that's absolutely the polar opposite of what we saw with environmental law. So there are efforts to make that even harder, called ag-gag laws. And those are dying a slow and welcome death in the US. There are several state laws that have been struck down as unconstitutional. These laws are seeking to criminalize the efforts of animal activists to access information that these entities are not required to provide to the public. So, for instance, it criminalizes the videotaping of what might happen in a factory farm if you were able to gain access to that facility. It criminalizes lying on an application that you're just trying to be an employee so you can gain access. So animal law has an opportunity to look to environmental law to get to a better place when it comes to access and dissemination of information. And that's very challenging. That's not going to happen overnight. So one of the chapters in the book does, chapter 9 in the book does talk about the idea of how can we transport what is doing such great things for environmental law into an animal law context. And one effort could be meat labeling as one example of this concept. So if there is an opportunity to convey to consumers, not even something that would be blatant or horrific, like a photo of a factory farm image on a package of meat, but something much less intrusive, like a carbon footprint label, because consumers are much more sensitive about the impact of climate change on their day-to-day lives. And if there were carbon footprint labels on meat packages, that might be one way to drive down demand through an information dissemination strategy that could work quite effectively. And that's just one of many potential opportunities. So the other piece about what separates environmental law from animal law and how environmental law has been able to succeed the way it has is because environmental law has a track record of broader standing to access the courts, to litigate claims involving environmental harms. And this has been a huge challenge for animal law. And the fundamental problem for animal law is that under US law, in most instances, to be able to sue to protect a harm to an animal, a human has to himself or herself be injured before that suit can go forward. And that's very different from the concept that environmental law operates from, in that humans are recognized as stewards of the environment under environmental law. For instance, we have an environmental protection agency in the US. We don't have an animal protection agency. So our environmental laws in the US are premised on this notion that citizens in many statutes can step in and sue on behalf of the government to correct an environmental violation. So that is not the same concept from animal law, where the human has to be somehow injured to sue on behalf of the animal. What we see in environmental law is a much broader opportunity to say you as the human have been harmed. And so that could include harm to your aesthetic interests, harm to your conservational interests, or harm to your recreational interests as an environmental plaintiff. The animal law standing field is much more restrictive, and that's been incredibly challenging for animal law jurisprudence to evolve the way environmental law jurisprudence had. So one effort to kind of bring animal law up to that point where environmental law has been is this idea of legal personhood for animals. So what's really remarkable is that this is a grossly misunderstood concept because of that word person in the term legal personhood. What many people overlook is the fact that many non-human entities are recognized with legal personhood, protected. Corporations, ships, and recent developments in Europe for robots. And around the world, natural resources are being recognized as having legal personhood. Rivers, wild rice. There are many examples where it's just so strange that animals would not be on that list if all of those other entities are. It seems relatively easy to make a compelling argument that primates and mammals are more entitled to a legal personhood protection than perhaps rivers might be. When you think about how much of our law is very anthropocentric in nature, how we're more interested in protecting entities that are human-like, certainly primates and mammals are much more human-like than rivers. And that's been a baffling, and I'd be scratching my head too about how many animals, certainly the highest on the animal evolutionary scale, the primates and mammals are not able to be readily included in that list. Of course, there are efforts that have been successful around the world to recognize certain types of primates and mammals as enjoying legal personhood, and that's been a very encouraging development of late. Again, most of those developments, if not all, have been happening outside the US. The US has been getting closer and closer to that first landmark recognition. But it is happening in many countries outside the US, and Latin America in particular has enjoyed many successes of late. But certainly we're seeing great progress on protection for natural resources for legal personhood in New Zealand, in Colombia, India. And in chapter 29 of the second edition of my book, there's also this notion of trying to integrate the notion of what it means to protect non-humans with legal personhood, this idea of ecosystem personhood. Because after all, animals are part of the natural resources ecosystem. So it seems somewhat strange to protect a forest or a river without protecting the animal inhabitants in both of those systems. So we're seeing those efforts with the Great Barrier Reef, and that's still unsuccessful, but gaining momentum in Australia. And with the Colombian Amazon, strangely enough, in a climate justice case, the Colombian Amazon was recognized with legal personhood in a climate justice case brought by Colombian youth a few years ago. So again, focusing our attention on what we mean by legal personhood is very important to clarify this message that legal personhood really means nothing more than who matters under the law. Who does the law want to protect? It doesn't have to be anything resembling what we understand people to mean, which we typically limit to humans. And then Steve Wise, the founder of the Non-Human Rights Project, says it very well here, that this paradox that the animals themselves are the ones who are injured and they don't have any rights, and those with the rights, humans, aren't injured under the way US standing law works. So that's what these efforts are trying to overcome, getting away from this paradox and moving to something that's more just. So of course, it's not hard to imagine the concerns that come with animal personhood. The first one that I have, and perhaps more so than many animal rights activists do, is that I really think legal personhood should be a legislative responsibility. It shouldn't be going on one case at a time. But I fully support the efforts that are going on in the courts because it's very difficult for legislatures to embrace animal legal personhood. So you have to start somewhere. You have to develop that momentum in the court system that will hopefully be transported up to a legislative initiative. As I mentioned earlier, the UK and other European countries are legislatively recognizing this idea of versions of legal personhood and recognition of intrinsic value of animals far better than other places around the world. So the other challenge with animal personhood, well, two others really, is that slippery slope problem. Where do we draw that line? Is it between warm-blooded and cold-blooded? Is it between higher primates and reptiles? It's very difficult to ultimately say where that line should be. And so sometimes the arguments are drawing that line might be based on these human-like qualities that some animals have and others don't. non-humans, we'll say, to be more inclusive, because we could be talking about insects. There's no limit to what could be entitled to legal personhood. And then there's the problem under US law that partial personhood, which is what we would have for animals, is kind of a moral problem, because in our history in the US, we had slaves who were recognized as 3/5 of a person. And that was just morally repugnant to be thinking about how certain humans would only be 3/5 of a person while others enjoy all of the protections that humans deserve under our Constitution. So there is that challenge as well, because when we talk about animal rights, we're talking about the right to be free from confinement, the right not to be tortured. We're not talking about a right to marry or a right to vote among animals, not in the near future anyway. So that makes it a challenge when we talk about conferring rights to animals, because it's not going to be the same set of rights that humans get, and that presents a legal complexity. But I like to think about this in a big picture kind of way, and I really see where we are with advancing efforts to recognize legal personhood for animals as the next stage of our cultural evolution. We have a track record of being careless and then correcting our mistakes. And that's something that is far from ideal. We should have never made those mistakes in the first instance, but at least when we look back on our human against human exploitation track records, we've made significant progress. Abolishing slavery, prohibiting several types of discrimination. Of course, we still have a long way to go in that second box, because you have to look no further than the Black Lives Matter movement and the Me Too movement and the LGBTQ movement to know that there are still a lot of things that we need to do better in prohibiting discrimination. But that's far better from the place we were decades ago. Women didn't even have the right to vote until the 1920s in the US. And of course, all of the other forms of cultural evolution, anti-discrimination efforts are very recent. So that's a work in progress, just like recognizing legal personhood for animals is a work in progress, because we have this long history of thinking of animals as property, both under the law and in our day-to-day lives. And so that's something that has to erode, and it is eroding. And that's really where we're headed next. It's just a question of how fast we're going to get there. So opportunities for collaboration, the first I would mention is the climate change, which is really everywhere. And it's a valuable opportunity for environmental and animal law to work together more effectively. And then this notion of common goals and means. So on climate change, this is something I've done some writing on lately, and I'll share a link to an article on this issue in the chat. When we think about factory farms, this is something that has been initially a concern for animal activists, just the horrific conditions and treatment of animals in CAFOs, concentrated animal feeding operations, factory farms. It's only more recently that factory farms came onto the radar of environmental activists as a huge source of pollution. Initially, that was limited to water and more traditional air pollutants, but of late, environmental activists are now focusing in on the methane emissions from factory farms and how that's a huge problem for climate change. So you can see how the first and the third items on this list are kind of animal law and environmental law in their own camps, but that middle ground in that second point is really where these two movements can coalesce. The idea that climate change is a massive public health threat, and that matters to both movements very much. Think about how we got ourselves into this pandemic, how all of the evidence is pointing to this transmission of wildlife trade, animal to human host, and we're in year 3 of this. That could have easily been avoided if we did a better job of limiting the exploitation of animals in that one context we would have been in a much better place. Of course, many other contexts should be addressed as well when we talk about animal exploitation. But on the public health side, when we think about doing a better job on regulating and phasing out factory farms, how this is a win-win-win, great for animals, great for the environment, great for human health. If these two movements can work together more effectively on that one issue, we would have significant progress. And then another book that I've written recently, this was published in 2019, this focuses on the idea that these two movements are really about stewardship. They're about providing a voice for those entities that don't have voices, whether we're talking about nature or animals. I add a third category in this book, future generations. So current youth and the yet to be born among the human population. All three of these categories are voiceless under the law. So when we think about how animal law and environmental law can work together more effectively, stewardship is really very much an environmental concept. The public trust doctrine is one example. We don't see that as much in animal law, and that's something there needs to be more partnering on. This idea that humans are stewards for both resources and animals, and that concept should be more entrenched in how we protect both resources and animals. Demand reduction is something that animal law has done better than environmental law has. So that's an opportunity for environmental law to learn a bit from the playbook of animal law. The idea of cage-free eggs as one example of demand reduction, that we want to do better for at least the welfare of animals by being mindful of how we want to drive down demand for things that are not sustainable, that are not humane. And then ultimately, litigation in both of these movements is very creative and needs to be very persistent, and there needs to be more sharing of notes between these movements, because they both do an outstanding job of these groundbreaking lawsuits, but they're often in their own camps when they do it. So there were tremendous successes in the animal law movement on the demand reduction side with the Ringling Brothers Circus, for instance, just by spreading the news about how inhumane those practices were in using bull hooks on elephants and the treatment of other animals in circuses. That messaging alone really shut down the Ringling Brothers Circus, 150-year tradition that was just shut down in a span of really a decade of effective advocacy. And of course, environmental law has done really effective jobs on the climate justice side with creative theories, some using the public trust doctrine, others using other theories. But it's about getting information to the public. Sometimes that's through litigation, sometimes it's through documentaries. And we've seen compelling documentaries from both movements. An Inconvenient Truth on the climate change side, Seaspiracy recently, and Blackfish, the picture of Tilikum, the orca in the slide here. So there is a lot of opportunity there for the two movements to build on each other's strengths. And then I'll close with these two examples from chapters in the book. One thing we're seeing even more so lately, just this year alone, is this idea of washing the public with misinformation. So greenwashing happened first in the environmental movement. Then we saw humane washing in the animal law movement. And they're the same premise. And so we need to share resources about, well, first of all, humane washing efforts can learn from many of the successes of greenwashing. But we're seeing more and more of a problem with this now in the climate change era. There is a whole new concern now called carbon washing or climate washing, where there are buzzwords out there that both companies and governments will use to say, we are carbon neutral, we're net zero, we're all these different buzzwords that make the public feel better about what's being done, but in many ways it's very misleading and just plain false about making meaningful strides in protecting what they're supposed to be doing. So these efforts are very much a common concern between the movement, getting these entities to be accountable for their efforts in misleading. And we're seeing a lot of that with climate change, and I think there's an opportunity for both movements to work together more effectively on that front. oops. And then lab-grown meat is something that I see as a really important opportunity for both movements, in that we're not going to make this transition from meat eating to plant-based diets overnight. We've seen a rapid transition toward plant-based options in the US and around the world, but lab-grown meat offers perhaps a very effective intermediate step between traditional meat and plant-based meat, in that it very much more replicates meat eaters' preference for texture and taste compared to plant-based, although I have no problem with plant-based meats. I think they're wonderful. But when you think about the general public, when lab-grown meat can truly replicate what a steak tastes like, that will do wonders for diminishing our carbon footprint and get us to phase out factory farms sooner, because that needs to happen as quickly as possible just to tackle the climate change crisis, let alone all of the animal welfare concerns that go along with that. One thing that's overlooked, though, in this transition is that transitioning to lab-grown meat is not environmentally perfect by any means. It actually contributes to the climate change problem. It is very energy intensive. It does involve some harm to animals for extracting cells to develop that lab-grown meat, so that's a concern for some animal rights activists. But ultimately, we have to be as pragmatic as possible, because we are facing such a crisis with climate change alone, let alone all the other threats to our resources and to animals, that the pragmatism has to involve more collaboration between these two movements to move things forward and not be perfectionists about what we're trying to achieve. And I'll stop there, and thank you very much for your attention, and look forward to your questions.
Thank you so much, Randall, for your presentation. I just wanted to ask, so as a person specialized in environmental law, how do you address the issue of the promotion of veganism? What's your attitude towards veganism?
Well, it's something that I am very passionate about. I think that what I found when I teach animal law, and this was never true teaching environmental law, is that the information that students have access to when they take an animal law course, it is remarkable, without any browbeating, how many of my students voluntarily transition to a plant-based diet when they have the information about what animal law involves, what the different forms of animal exploitation are. And that was my experience as well. I was an environmental law professor for 2 decades. It never occurred to me that my food choices are a very important part of what it means to be an environmentalist. Never occurred to me. And frankly, about 90% of my environmental law colleagues are not plant-based eaters, which is shocking. On the animal law side, easily 95% of my animal law professor colleagues are plant-based eaters. So I think the vegan agenda is very important, and it needs to move away from some of the baggage it's had in the past. And I can say that one area where veganism has run into trouble is being a little too strident, that it's an all or nothing proposition, that unless you are 100% vegan, including not wearing any animal products, you are not doing it right. And I think that's a flaw in the movement, that of course it's far better for the planet and for humanity if we have many more vegetarians instead of the vast majority of people being meat eaters. So I really respect this agenda that veganism has, but I say so with that caution that it needs to be a little more patient and inclusive of those who are trying to make a transition. When I made my transition, I was a pescatarian for about a year before I ultimately transitioned to plant-based. And I wouldn't want vegans calling me a coward because I was transitioning away from a meat-based diet to pescatarian first before I went fully plant-based. I'm doing the right thing. I'm going to get there. And I just think there needs to be more of that cooperation to promote the value of veganism to the to the public. My other frustration, though, is that in America anyway, the best way to help that transition is to get vegan choices in our fast food restaurants. And it's been just exasperatingly slow to see vegan options on fast food menus. This year alone, we're seeing some rollout of several items at several fast food restaurants. So that's long overdue, and that's encouraging.
Thank you so much for this very detailed answer. Yeah, I'm sure that with this issue, there are a lot of challenges that one may face. I don't think we have the questions from the attendees. In case if those who attended have questions, you can just send them directly to Professor Abate, and he will answer them. I don't know, through email or whichever way works for you. Thanks again, Randall, for doing this presentation. I was enjoying your talk, and I was glad to learn more about your perspective and actually the connection between animal law and environmental law. And I'm sure that those who will be watching the recording will find this useful as well.
Thank you very much. And I really want to encourage the attendees or those who watch the recording afterwards to reach out. I'm happy to be a resource. I've worked with many students in law school who are seeking to pursue careers in animal law and or environmental law. And just really, it's what I enjoy the most about my career, being able to mentor those who are new to these fields and help them find a path in their in their careers, especially early on, because that's when it's most challenging.
Yes, true. I, as a professor now, am trying to encourage more students to be involved in animal law, animal protection, and actually raise awareness about the issues, the global issues that affect all of our lives. So I completely understand. Well, thanks again. And so the recording of the webinar will be available in the near future. Thanks again to those who attended the webinar, and have a great day.
Thank you.